Oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5163 et al. Campaign for Accountability versus United States Department of Justice appellants. Mr. Tenney for the appellant, Mr. Abdo for the appellee.
Good morning, counsel. Mr. Tenney, please proceed when you're ready.
May it please the court. Plaintiff has not identified any category of OLC opinions that would cause a need to deviate from this court's analysis in Electronic Frontier Foundation, regardless of the precise context in which the need for an OLC opinion arises. OLC is still at bottom providing legal advice to agencies who then in turn make policy decisions or other agency actions that may or may not be subject themselves to the reading room provisions of the FOIA. The particular category that the district court identified was resolving disputes between agencies, but there's nothing fundamentally different about those opinions than any others. In fact, the very opinion in Electronic Frontier Foundation itself reflected a disagreement between the Office of Inspector General and the FBI about a legal question. And although that case arose because it was the FBI that went to OLC for an opinion rather than a joint request from the FBI and OIG, there's no basis for concluding that this court would have come to the opposite conclusion if formally both of them had gone to OLC and said, we don't agree about this, as opposed to the FBI going itself. And in fact, as the record reflects, there's not really a difference, and OLC doesn't track, which of its opinions arise from interagency disputes and which don't. In each case, OLC is just making a determination based on its discussions with one or more agencies and rendering legal advice. And that legal advice is subject to the deliberative process privilege and doesn't constitute a final opinion or a statement of policy or interpretation adopted by an agency, and therefore is not subject to the reading room provisions.
Mr. Tenney, can I ask you a threshold question about CFA's standing? What do you think they need to show to establish standing under TransUnion and this court's precedents, such as in prosology? Because the reading room provision is unlike the individual FOIA provision, where we have said that a person who seeks information and is denied it has informational standing. The reading room provision is a general obligation on the government. So what do they need to show to establish standing after TransUnion?
I mean, they did ask for information, and this court and others have recognized that you still need to exhaust your claims. And as the district court recognized in this case, the only relief they can get is not relief that would require the government to comply with the reading room provision and put the materials on a website, but rather just provide it to them. So I'm not sure they're differently situated in the sense that they have asked OLC for the information, they've received responses. So even though they didn't make a request under A3, which is typical, we haven't taken issue with the idea that they're still a requester of information.
So are you suggesting that they have standing because their request is sort of functionally like an A3 request?
I mean, to be clear, we haven't contested standing. We haven't taken.
I know. I'm just interested in the government's position.
A position on it.
We have to independently.
Right. No, I understand that, and I guess we haven't identified a distinction between asking for information that you think the agency was compelled to make public under A2 and asking the agency to provide that information to you, which you think is required under this court's case law, and filing a request under A3 for the same or similar information. I mean, that's not an issue that we've briefed or argued, but we haven't made an argument along those lines.
And we have this decision prosology where this similar issue came up, and one of the points that the court made in the course of that opinion was that the information in other cases involving A3 was sought and then it was denied. I'm sorry, A2, the reading room provision. And here I take it that it seems like functionally that's what happened, that the requesters asked for the information and then under the reading room provision and then were rebuffed.
Yeah, that's correct. And they're both initially and then, they filed an amended complaint and then there's in the record a response from OLC. I mean, it was to the complaint in court, but it was still, OLC providing an answer about what, that it was not planning to provide this information. And as I pointed out, the district court recognized that the relief that they are asking for and the only relief that they could get is producing the documents to them.
So is it fair to say then from the government's perspective, as Judge Rowe says, we have to consider standing no matter what, but is it fair to say that the government's position is that you don't see that there's a standing problem here? We have to make that assessment in the first instance,
right.
Whether we agree with that, but that's.
I mean, we certainly haven't identified one or argued that there's no standing and so, we're not asking the court to rule on that ground. And I think if the court were to conclude that they have made a request in this case and concluded that that was sufficient to satisfy this court's precedents, that would be a reasonable resolution of the standing issue here.
Can I ask a question about the merits? Unless just follow up on the standing. So there's kind of mirror image ways of looking at this. One is the way the government presents the case is should look to see whether these opinions fall within the deliberative process privilege. And if they do, the case is over. And the way that the district court looked at it and the way that the requesters look at it is kind of the opposite. Look, these fit within the reading room provision, and therefore they have to be disclosed. And is there an order of operations that you think has to govern, or do you think it's up to the court just to choose which way to proceed?
Fundamentally, the question under both approaches is the same, which is whether this is final or whether it's pre-decisional. And I mean, I guess a few points. One is it's definitely correct that if the deliberative process privilege applies, then there's no obligation to disclose, regardless of what the reading room provision says. That the district court recognized that, and the 552B is an exemption from the entire act. So in that sense, you could certainly resolve the case on that ground. But I think the reason we focus so much on the deliberative process privilege is as much that is the issue that this court has already resolved, and because everyone understands, and the Supreme Court has said that if something is deliberative, then it's necessarily pre-decisional, and then it can't be a final decision or an adopted statement of policy, that the logic of Electronic Frontier Foundation means that the government wins whichever way you look at it, whether you look at it under B5 or whether you look at it as a question of whether the reading room provision applies.
So I guess one scenario that could play out, and just correct me if I'm wrong and not understanding how FOIA processing works, but one scenario that at least conceptually occurs to me is that if we focus on the reading room provisions and we say that the reading room provision that these documents don't fit within the reading room provision, then there's not an affirmative obligation on the part of the government to post them. But then that wouldn't be to the exclusion of filing an individual request under A3. Is that right?
That is true.
And then would that then just tee up whether in response to that request, whatever set of opinions is sought is protected by the deliberative process privilege?
Right. If the court were to hold that the reading room provisions don't apply to these categories, and it would have to hold, in order for plaintiff to prevail, it would have to hold that it applies to all the opinions in some category, which seems plainly not true. Then obviously the logic of the court's opinion in that regard might control or at least highly influence a subsequent analysis of whether the deliberative process privilege applies if these opinions were requested through A3 on an individual or categorical basis. But there can be a circumstance, and this court has explained it, I think in Afshar, that where materials are not subject to the reading room provisions, but nonetheless must be provided upon request. And so the court could leave that possibility open, Since all of the issues are briefed here, and since as I said, in this particular context, the analysis that would lead the court to conclude that the reading room provisions don't apply would also lead the court to conclude that the deliberative process privilege does apply. It might be helpful for the parties if the court were to say all of that in resolving this case, but I don't disagree that if the court simply wanted to say the reading room provisions don't apply and therefore this complaint should have been dismissed in its entirety or summary judgment granted for the government on the one count that wasn't dismissed, then that would properly dispose of the case.
But then would that not at least leave open conceptually the possibility? I mean, obviously, how it's written would affect things, but if that scenario played out, would it conceptually leave open the possibility that then an A3 request could be made, and then the deliberative process privilege would be asserted, and then the courts would be faced with squarely confronting that question?
That's right. If the court, the mere fact that the court had held that the reading room provisions didn't apply would not preclude a subsequent request along those lines. The logic of the court's opinion might well preclude it.
So could there be a request for all OLC opinions resolving interagency disputes that were adopted by the agencies?
I mean, I think you would, in that circumstance, you would have to determine whether that was whether that request reasonably described particularly the documents, because there could be some legal disputes about what was and wasn't adopted. And so
I'm interested in that just because from the perspective of a requester, they don't know what interagency disputes have been presented to OLC, but there might be some subset of them that would qualify under the reading room, even if most OLC opinions are pre-decisional advisory type things. Once they're adopted, I think it's clear that they would be subject to the reading room exception, and also not subject to the deliberative process privilege. So how does a requester get at the things that they might be entitled to get?
I guess a couple of responses. In terms of the reading room provision, the agency that would be subject to a requirement under the reading room provision would be the one that adopted the opinion, because that would be the agency that had made
the FOIA request could be made to OLC because the documents are also in your possession.
Right. And I guess I was getting the point I'm trying to make is that the OLC might not have an obligation under the reading room provision to provide the document. If OLC were aware that a particular document had been adopted by another agency, which would constitute a waiver of the privilege, then if a request was made to OLC for that opinion and it had not already been made public, then OLC would not claim the privilege over that opinion and would provide that opinion to the requester under A3. And OLC in this case has already expressed that it would intend to do that. So a requester could simply file an A3 request to OLC, and OLC, I mean, the other thing that OLC did in this case is make discretionary releases of some of the opinions that fall in the categories that plaintiffs have asked for. So a requester doesn't have to say only the ones that are adopted or only the ones that, aren't. I mean, if there's a particular category of OLC opinions that a requester wants, it can ask for them. And then OLC will make a determination about whether they're privileged, which some of them may not be if they've already been adopted, and B, even if they're privileged, whether the government wants to waive the privilege and make a discretionary release of the opinions. And it regularly does so.
So are you saying that if a requester asks for all OLC opinions resolving interagency disputes, OLC on its own initiative looks at all of those and decides which ones have been adopted or which ones otherwise are not privileged and releases those?
With a caveat that as explained in the record, OLC doesn't actually track which of its opinions formally arose from interagency disputes, because those aren't a particularly distinct category of decisions. But as a general matter, if someone makes a request for some defined category, and so OLC would have to figure out whether that was a category that it could ascertain. But if as a general matter, if someone makes a request to OLC for some category of opinion, a proper FOIA request stipulating that it's a proper FOIA request for some category of OLC opinions, then OLC, does a search, concludes whether there are opinions in the category requested, determines whether it wants to release them regardless of any privilege or if any privilege has been waived. And in fact, some of the opinions, that would have fallen within this case have been discretionarily released.
So if they make a request for all OLC opinions, OLC looks through all of its opinions and decides which ones are not subject to.
Again, I mean, there are separate questions about the breadth of a request and, what the agency needs to do in responding to a request of that scope. But if you sort of, I don't understand that to be the thrust of your question. So
I'm
if,
just interested in how does a requester who actually might be entitled to get some of this information make a request that reveals that information?
I mean, I can certainly tell you that people make requests for OLC opinions on particular topics, OLC opinions in particular timeframes, OLC opinions with particular characteristics, and OLC processes those. And sometimes the opinions have already been discretionarily released. Sometimes OLC concludes that it's prepared to release those as a discretionary matter. And sometimes as an electronic frontier foundation, OLC claims that they're privileged or subject to some other FOIA exemption under, and therefore withholds them. And that's no different from any other agency. And, there's nothing to stop anybody from doing that.
Right. Is the upshot of your position that unless OLC discretionarily releases an opinion, which obviously can always happen, that every OLC opinion is protected by the deliberative process privilege? So OLC never, as a matter of FOIA, has to disclose an opinion. It may be that another agency might adopt an OLC opinion, and then that other agency might be required to disclose it as a matter of FOIA, but OLC is never required to release an opinion, even if it's ultimately adopted by another agency. OLC itself is never required to release an opinion in response to a FOIA request. Is that the upshot of the government's argument?
Not quite. There's one caveat. If you substituted in response to a request with under the reading room provisions, then that would be correct.
Yeah. Okay.
If there is a request for an opinion that a different agency has adopted, then OLC would no longer treat that as privileged and therefore subject to other exemptions would have an obligation to release it pursuant to a request.
But it's not
Correct.
It's not that they would discretionarily not treat it as privileged. It's just that the privilege wouldn't work anyway because will have been waived.
That's correct. But so in direct response to your question, there could be a circumstance in which OLC, in response to a request, as is distinguished from under the reading room provisions, would have an obligation.
One other question on this. So the way that this case has come up and then the way EFF, Electronic Frontier Foundation, was litigated, it's OLC, the relevant agency is the agency that requests the opinion from OLC. And then the question is, for reading room provision purposes, whether there's finality and it's congealed into an opinion and those kinds of things with respect to this other agency. And the logic is that what OLC does, even if it's practically treated as binding vis-a-vis the other executive branch agency, it doesn't dictate something that the other agency has to do. What about a request that is predicated on the logic that the agency is OLC or DOJ itself, and it's final as to OLC, DOJ itself, regardless of what may ultimately ensue with respect to another agency?
I mean, that is an argument, or at least a version of argument that has been advanced in Electronic Frontier Foundation and in CREW and in this case. And I mean, you can always say that when there's an executive branch decision being made, if some component of the executive branch has provided advice, for example, if the Department of Defense were making a determination about whether to engage in some course of conduct and it asked EPA for advice about the environmental consequences, then EPA would provide its advice, and that might be final as to what EPA is saying, but nobody would think that that's a final decision because the final decision is the one that's being made by the Department of Defense. And all of the rationales for the deliberative process privilege would apply in that circumstance because you wouldn't want people to know that the Department of Defense had asked EPA what advice EPA had given. EPA would want to be able to give advice candidly and freely without revealing it to the public. And so the mere fact that the consulting agency's or the consulting components don't all fall within the same executive branch agency doesn't mean that the advice rendered by one component of the executive branch is final in the relevant sense for purposes of the deliberative process privilege. I mean, this court decades ago, has recognized that principle in the context of, agencies making budget requests. And if they make a budget request to OMB, even if the agency's done, nobody thinks that the budget request is other than deliberative because OMB or the president is the one that's ultimately going to decide.
So reframing the relevant agency from the government's perspective wouldn't change anything in reality, and therefore it doesn't change the way you've put the case, stop operation of the deliberative process privilege as a bar against disclosure.
Right. The point is that the question is the way this fits into the determination of what policy to adopt. And if there is some step of that process that is merely a step and not the finality of that process, then that is pre-decisional and deliberative, and who is doing it is not what matters.
Can I just ask you a factual question? When OLC gives one of these opinions to another agency, and if the agency adopts the OLC opinion formally as part of its decision-making process, does the agency usually in that situation check with OLC before making a disclosure of an OLC opinion?
It's a hard question to answer because it's actually quite uncommon that agencies do adopt OLC opinions. I mean, they're legal advice in the same way that if the general counsel of a company or of an agency provided advice, it would be unusual that.
Usual, but it's not never. I mean, sometimes agencies want to say that what they're doing has been supported by an opinion from OLC. So I'm just wondering in those situations, if that agency is then free to just release the OLC opinion.
I mean, just to be clear, if an agency says that what it's doing is supported by OLC, that is different from saying the reasons that we're taking this action are all of the reasons that were set out in the OLC opinion. So that might not constitute adoption.
Right.
And so
if they fully adopt the OLC
but
opinion.
if they say we are taking this action for the reasons stated in the OLC opinion of this state, I don't know that comes up enough that I can tell you that there's a general rule. It would surprise me if an agency did that without talking to OLC about it, but I can't stand here and tell you from practical experience that I know the answer of how that would play out.
Thank you.
No further questions. All right.
Thank you, Your
We'll
Honor.
give you a little time for rebuttal. Mr. Abdo.
Good morning, and may it please the court. Congress enacted FOIA's reading room provision to prevent the accumulation of secret law. And yet the OLC argues that may continue to suppress the three categories of opinions at issue here, even though these opinions directly establish the law and policy of the agencies that solicit them. The government's entire argument rests on this court's decision in EFF, but its interpretation of that case is wrong for two fundamental reasons. First, EFF did not involve a claim under 552A2A. The core reasoning of the case focused on whether the OLC opinion at issue determined agency policy or had been adopted. Those considerations are relevant under A2B, which requires the disclosure of opinions of statements of policy which have been adopted, but they're not relevant to 552A2A. And so EFF is no barrier to our claims with respect to two of the three categories at issue. And that's the reasoning that then Judge Jackson and Judge Cobb both relied on in ruling that the category of opinions resolving interagency disputes must be disclosed under the reading room provision. Second, even under 552A2B, EFF just isn't categorical. It made clear that OLC opinions qualify as working law when they speak with authority on agency law or policy. The opinion in EFF didn't speak with authority because it wasn't sought to establish the law of the agency, and because, as the court said, it merely examined policy options. But the three categories of opinions at issue here do speak with authority. The explanation why is unique to each category, but generally for each, they are sought to establish agency law or policy, and there is no distance between the OLC's legal conclusions and agency law or policy.
Can I ask you about the first? You said you had two distinctions, and on the first one, but EFF was about the deliberative process privilege at the end of the day, right?
That's right.
So if EFF governs with respect to the deliberative process privilege and put aside your second ground for distinction, then how could it matter that, because then the deliberative process privilege is just a bar
I don't think that's right. If, as a textual matter, these opinions fall within A2A, if they're final opinions made in the adjudication of cases, and the Supreme Court said very clearly in Sears, A2A opinions may never be withheld under Exemption 5. That means they are, as a category, simply
I don't know
not
about that,
deliberative.
because I thought in Sears, there's also a footnote.
There is a footnote that says
21, I think.
hypothetically. That's right. There's a
Yeah.
footnote that says hypothetically, if an opinion could be both deliberative and a final opinion, then maybe the court would have to resolve this question. But it made
No, I
clear.
thought what that footnote said is then it would be within the deliberative process privilege and therefore didn't need to be.
Right, you're correct, but the court made clear that those opinions, by virtue of falling within A2A, were not deliberative. And the same is true here with respect to these three categories.
Right, but I guess I don't understand the
Sorry, two
logic of that,
categories.
because I think what that footnote indicates is what the text of the statute seems to indicate, which is that if something falls within the deliberative process privilege, then the rest of the act doesn't apply, including the reading room privilege. And so I think I think there's a lot to what you're saying, which is that what the presupposition of Sears is that this practically may never come up, because for the same reason something falls within or without the reading room provisions, it may fall within or without the deliberative process privilege. And so the Venn diagrams don't ever overlap. And so you're never going to be faced with this. But it did seem like what that footnote said, and what's echoed by the statutory structure, is that if you engage the possibility that the Venn diagrams overlap to some extent, then the deliberative process privilege governs. And if something falls within the deliberative process privilege, then it doesn't. It can't fall. It can't be required to be disclosed under the reading room.
I think that's right, but the considerations that this court addressed in EFF are not general deliberative process privilege questions.
Mm-hmm.
The questions that the court addressed were, did the OLC speak with authority? And even if not, was the opinion adopted? Those are two ways by which an opinion might fall within A to B and therefore not be deliberative as in the working law framework. But it doesn't engage the question of whether if something is otherwise a final opinion made in the adjudication of a case, it is somehow deliberative. And I think just as a practical matter, it isn't. Let me give you an example from our second category. The second category involves situations where an agency is actually adjudicating a claim of private right. The adjudication turns on some question of law, and they go to the OLC for an authoritative statement of the law that applies to that adjudication.
They being an agency.
They being the agency goes to the OLC. And in that circumstance, the opinions that the OLC issues are then, they're sought specifically to establish the law of the case, the law of the underlying adjudication. And those opinions are materially indistinguishable from this court's past opinions in Coastal States, Tax Analyst 1 and 2, and Schleffer. There's simply no material distinction. An agency adjudicator goes to an agency lawyer to get the law that applies to the adjudication, and this court held correctly in those four cases and others that those resulting opinions are not deliberative. They are instead the law of the agency, because in the circumstances, they are sought specifically to establish the law.
So I mean, you're right to rely on prior cases, and because we've had a lot of cases that say a lot of things. And I guess it looked like what EFF did was it took into account those same cases, including the tax analyst cases, and it drew a distinction based on the fact that in those cases, there was a top-down dynamic at work. And within the agency, what was going on is the legal opinion that was at issue was a directive, and it was binding on people who are lower in the organization. And that just doesn't, what EFF seemed to say is that's not what's the dynamic when another agency requests an an OLC opinion. That's not the same dynamic, because the requesting agency, yes, as a practical matter, their OLC opinions are controlling, but EFF specifically wrestled with whether they're binding in the sense that they are final and operative for reading room provision purposes, and EFF seemed to indicate that they wouldn't.
I think EFF applied that logic to a single, not that logic, it just found that the single opinion at issue was flowing upward in the context of a decision-making process. It did not purport to establish a categorical bar to the application of FOIA to the OLC, and it couldn't have. The OLC's opinions in the context of the categories that we're talking about do in fact flow downward from the agency that is given the authoritative power to interpret the statutes and laws at issue to an agency that is tasked simply with implementing them. When, for example, in the attorney's fees opinion that we point to, there was a $150,000 award of attorney's fees. It was unclear which agency defendant was obligated to pay it. A federal statute said the agency over which the party prevailed has to pay. And the agencies went to the OLC, tell us which agency, and the OLC said HUD, the Department of Housing and Urban Development, is that agency. There was no decision to be made at that point. HUD bore the legal responsibility to pay those fees, and it flowed downward. There was no ongoing deliberation, and the same is true in our first category. There is no deliberation when two agencies bring established policies to the OLC. For example, in the reservist leave opinion that we point to, there are two agencies that have different policies on reservist leave. The VA, the Department of Veteran Affairs, said military reservists can choose which form of statutory leave to use first. That was their policy, and that's what their reservists were operating under. The Office of Personnel Management had the opposite policy. It said they couldn't choose. They had to use Category 1 before going on to Category 2. Two established policies, no deliberation, and the OLC said the VA's policy was correct. There was no further decision to be made at that point with respect to those policies.
So it seems to me that it's problematic for you that you are trying to get a ruling that applies to a whole category of cases. And you're pointing to these specific examples that seem to support your position. But there could be situations where OLC issues an opinion and then nobody does anything with it. They haven't adopted it. They just haven't used it. And also, I think it's also problematic if you want to rely on subsection A, you're trying to say that a final opinion of OLC is made in the adjudication of cases by the agency. Because the adjudication is by the agencies, but the final opinion is by OLC. So I see those as two potential weaknesses.
Respectfully, I don't think either is a problem. In this court's past cases, it adopted this precise categorical approach. For example, in Tax Analyst 2, technical assistance memoranda of the Chief Counsel of the IRS were at issue. And the court took a category by category approach and said some...
I don't have any problem with taking a category by category approach generally. I'm just saying under the circumstances that you're presenting, you're saying in every case, OLC issues an opinion and it is...
Well, we're not saying in every case. We're saying with respect to only these three narrow categories. And these are narrow categories with respect to the
every
OLC.
case in the category, but isn't there a possibility that the OLC could issue an opinion in an interagency dispute and then nobody does anything with it?
I don't
it's
think...
not adopted.
Our understanding, the record reflects that the examples that we put into the record are emblematic of the category as a whole, and the government has never disputed that. It has released 1,400 opinions. We've studied every single one, and we're not aware of examples in the categories that we have pointed to that are of the nature that you're describing. But if there were, the rare off chance that one happened to fall, otherwise fit within the category as this court described it in a ruling, and the OLC maintained that for whatever reason, there was some feature of this opinion that was salient in the analysis that wasn't in the category generally, the OLC would always at that point be able to withhold it and we could have litigation over that. But they haven't disputed, I don't think, that the categories we've identified, the examples we put in the record are emblematic of the categories. And that mode of analysis, by the way, was how the court engaged the question in Tax Analyst 2. There were technical assistance memoranda that fit within 3 or 4 different categories. The court said one of them was working law, the rest weren't, and even within the category of working law, some were unique, and the court allowed their withholding. That's all we're asking for here. I forget the second.
If you want to rely on subsection A,
yeah,
it says final opinions made in the adjudication of cases. But
right.
It seems to me that your analysis is the final opinion is by OLC, but the adjudication of cases is by the agency.
That's right, but I don't think that matters. When the OLC issues the opinion, at that moment, it is the final opinion made in the adjudication of a case, and it is.
And how is it a case?
It depends on the two different categories are slightly different. So the second category is there is obviously an adjudication going on below. For example, in the Social Security Administration case, the DOMA case that we point to, the Social Security Administration was adjudicating a claim for insurance benefits on behalf of a specific individual, Elijah, who is the son of women in a same-sex marriage, a same-sex civil union, in Vermont. And the question arose whether the Defense of Marriage Act foreclosed Elijah's entitlement to benefits.
I understand that
was
right. How's an interagency dispute a case?
For the reasons
that
then, right, for the reasons that then Judge Jackson explained. The OLC has a process that is both statutorily provided for and provided for by executive order to adjudicate disputes between settled policies of agencies. The agencies...
But those sources don't say that what advice OLC gives is binding.
Well, the government concedes that OLC opinions are binding, and they are in fact binding for 200 years.
But those sources don't say it's binding, just for purposes of saying adjudicating a case.
Well, I'm not sure that's right. I think 28 USC 512 makes very clear that the opinions of the Attorney General are the opinions of the executive branch. The government has never disputed in this case. It used to 10 years ago, it used to dispute that OLC opinions were binding. But all over its brief in this case, it has made clear that its opinions are binding. It says so in the best practices memo. And for 200 years, not a single OLC opinion has been contravened by an underlying agency. There's just no question. I mean, even in this court's past cases.
That's when they publish an opinion. I mean, agencies, as a practical matter, sometimes disregard OLC's advice.
I don't think that's accurate, Judge Rowe. And it's not just when the OLC publishes an opinion. The scholarship suggests that for 200 years, every OLC opinion that has been issued has been treated as binding by the agencies that receive them, and the government has not identified a single instance to the contrary in any case, let alone this one. But even if there was some question as to whether the opinions are binding, in coastal states in Tax Analyst 1 and 2 and Schleffer, this court made clear that they didn't need to be binding as a formal matter for them to constitute working law. They needed to be held in high regard and generally followed, and that was sufficient in those cases. They didn't insist on binding. The only thing—
Mr. Abdo, if I can ask you about standing, I'd like to give you
Sure.
an opportunity to address that, because our case in prosology recognizes that there is a meaningful difference between the reading room provision of FOIA and, the provision for individual requests of information with respect to standing. And that was even before TransUnion. And then TransUnion says for informational injuries, you need a downstream harm. And so here, your organization is trying to enforce the reading room provision. What is the particularized harm to your organization? How do you satisfy the concerns that were reflected both in prosology and in TransUnion?
I think this question is effectively resolved by Crew 1, this court's decision in Crew 1, and also the Supreme Court's decision in Sears. Our client, the Campaign for Accountability, filed a request with the agency asking for the OLC's opinions retrospectively and prospectively. The OLC denied it, and we sued. That's the fact pattern under Crew 1 that this court said would allow a court to—
But Crew 1 was before both prosology and TransUnion, wasn't it? I think so.
I don't remember. I don't know I think TransUnion was 2 years ago. I think, was that right? I don't remember the year of TransUnion. That may be right, but I think the standing analysis is still the same. We requested the records. FOIA has a judicial review provision that this court in Crew 1 said could be enforced. And the fact pattern of Sears, by the way, is—
Have you requested the records under both A2 and A3, or just under the reading room provision?
I don't
The
think—
reading room provision is meaningfully different.
I don't think the opinion identified A3 as the basis, but I'm not sure that matters. We requested the opinions. We were denied them. That's an informational harm
It's
that
an
is—
informational harm under A3.
If you
Why
want—
is it an informational harm under A2, which is the provision that you're trying to, Campaign for Accountability is trying to get OLC to publish these things on their own, which is a general obligation that the agency has under FOIA. So to sue for that, there has to be some particularized harm.
It's a harm because we want them in the future, and the agency has made clear in the future it will continue to treat the question of whether to publish them as entirely within its own discretion. That, by the way, was the fact pattern of Sears. A request was filed, and the court issued a ruling not under A3, but under A2A. I don't think there's any material distinction between the decision Sears and the way that we're proceeding here. But if you're troubled by that, you could treat it as a decision under— you could treat our request as a request under A2 and then limit the relief if you want. I'm not sure as a practical matter that will have any significant result, but—
I don't think it would be open to us to treat it as a request under A3.
Excuse me, A3. I meant to say A3.
That wasn't the request that was made.
The request was
wasn't
just made
the—
for opinions. I think that counts as a request under A3. We didn't identify A3 as a request, but there's no obligation to use magic words when filing FOIA requests for the agencies.
In the remedy you requested, was it just that it be released to you, or that the agencies publish it as a reading?
We asked that they be released to us, and that they also release indices to us, and that's the form of relief that this court in Crew 1 said was available.
So you just asked for it to be released to you. So it seems that the injury is identical to if you had made an A3 request. You're just asking that the information be released to you.
That's right. And when this— I forget the year that Crew 1 was decided, but it's not available to us to ask for release to the public under this court's decision in Crew 1.
Isn't the relief that you're asking for broader than— I mean, you're saying you want forward-looking relief for OLC to make these categories of opinions available under the reading room provision.
Yes, that's right. But
Which is different than an A3 request. That would be just to CFA.
that's right. It's different than an A3 request. If you don't think we have standing to seek the prospective relief, then you could limit our relief to retrospective. That would still have a significant effect. But I don't think there's any meaningful distinction between how we're proceeding and the path that the court laid out in Crew 1. And I don't think TransUnion calls standing in that context into question, because we filed a request. There's no question that the OLC in the future is going to treat its opinions in the same way that it's treating them now. And so we will continue to suffer the harm that we're suffering now, which is not getting records that we think we're statutorily entitled to. I may not have persuaded you.
No, I'm just saying that's an A3 harm, though. That's not a A2 harm. That A2 requires agencies to just make these things available. So it's reading room provision.
I understand. And if the court wants to treat the request as one under A3 and limit the relief that we get to A3 relief for that reason, it would still, be possible for the court to reach the legal questions that are up on appeal.
Thank you.
Can I ask on the EFF applicability, there's the dynamic that you've outlined about a situation in which two agencies come in and want an opinion, and then the way you see it, there's nothing yet left to be done because the OLC issues an opinion. It's the referee who decides the dispute, and then that opinion becomes operative by the way this plays out. Then one of the government's responses is, well, you could manufacture the same situation in EFF itself and have another agency come in and express that it has a contrary view and you just want that to be resolved. And would EFF have turned out differently if it had arisen in that context?
I don't think the OLC would have issued an opinion in that context. The best practices memo makes very clear at page 300 of the joint appendix that the OLC doesn't issue opinions in abstract legal disputes. It wants essentially a case or controversy. And if you look at that description of when it issues opinions, it's effectively a case or controversy requirement for the OLC. But it is true that depending on context, an opinion in one, may or may not be working law or may not be a final opinion made in the adjudication of cases. But that is the lesson of this court's past cases, that context matters. And tax analysts, too, the court made very clear that an identical memorandum that travels upward versus horizontally might in the former case be a deliberative advice and might in the latter case be the working law of the agency that receives it. I don't think that's a problem. If the government were actually pointing to examples in the record or had even tried to submit some under seal where there are interagency dispute resolutions or opinions in categories 2 or 3 that bore the characteristics that we described, but that were nonetheless deliberative, then I think they'd have an argument, but they haven't done that. Their only argument is that the OLC's conclusive resolution of a policy dispute or its establishment of the law that an agency will apply in an adjudication or its determination of what a non-discretionary legal obligation means, its only argument is that those are all deliberative because the OLC at the end of the day is a legal entity. But this court has already rejected that logic, and I don't think EFF could have undone the decades of this court's past precedent, recognizing that legal opinions can sometimes be the working law of the agencies that request them based on the circumstances of their solicitation and their issuance. And that fundamentally is the rule that we're asking this court to apply, to recognize that context matters and to recognize that these 3 categories of opinions, when they're issued, there's no distance between the legal determinations made and the underlying law and policy of the agencies that solicit them.
And it sounds to me that from your explanation just now, that you don't see a difference at the end of the day based on whether we view it as the applicability of the deliberative process privilege on one end or the applicability of the reading room provisions on the other end, because they ultimately turn on the same considerations anyway.
I think that's right. I think the easiest way to resolve the first 2 categories is to apply the text of A2A instead of relying on amorphous considerations of deliberation. I think A2A is very clear as a textual matter. The Supreme Court interpreted it in Sears, and this court can just apply the text of A2A in resolving categories 1 and 2, and then rely on the court's observation in Sears that final opinions are effectively never going to be deliberative because those 2 categories just don't overlap. I think for the third category, you could approach it in either way. The third category is the only one where you have to address the considerations from EFF, because the argument we're making there is that the opinions issued in that category reflect a statement
I'm
of
sorry,
policy.
which category?
The third category, the opinions interpreting non-discretionary legal obligations. And our argument with respect to that category, again, is that when the OLC issues those decisions, it is deciding the underlying agency's policy because the legal obligation is non-discretionary. There's no further work to be done before coming up with a policy. For that category, I think you do have to address EFF, but I think the category satisfies the requirements of EFF, again, because there's no distance between law and policy in that context.
My colleagues have additional questions for you? Okay,
Thank you.
thank you. Mr. Tenney, we'll give you 2 minutes for rebuttal.
Just 3 quick points, 1 general and 2 about specific categories. The general point is that ultimately what this court deemed conclusive in EFF is true of all opinions, which is where they flow. They flow from OLC to some agency that has that ultimately has policymaking authority. And that's true whether it's resolving a case, that's true regardless of the degree to which it constrains the agency's policy, the legal framework constrains the agency's policymaking discretion. That's just true across the board. And there's really no escaping that. The 2 specific points, counsel asserted that we hadn't identified any opinions that resolve interagency disputes, but still leave policy making discretion. We did on page 20 of our response reply brief, where OLC advised that EPA had authority to assess civil penalties against federal agencies. EPA then could make a decision about whether it wanted to do that or not. So that wasn't a final decision. EPA still got to decide what it wanted to do. So that's just illustrative of the general problem here, which is that these opinions go to agencies. They may leave the agency with more or less discretion at the end of the day, but ultimately the agency has to do something and decide what to do. And that's the final decision. That's not deliberative. And then finally, on the category of, what happens if, as a practical matter, the legal decision leaves little or no room for the agency to, make policy adjustments. I mean, that's Murphy. In Murphy, the general counsel of the Army was deciding whether there was a binding contract or not and whether the agency should keep working on it. And this court said, it doesn't matter whether the general counsel, as a practical matter, was telling them something that they had to abide by, because the ultimate policy decision was made by the policymaking official and not by the general counsel. So ultimately, all of the categories boil down to, this is legal advice, somebody makes a policy decision, that policy decision is the final decision, and the legal advice is deliberative.
Can I ask you, that isn't true in tax analysts, that same interplay? That the legal opinion that was sought is legal advice, and then somebody makes a decision based on that legal advice.
Well, so in tax analysts, and obviously this court reviewed that in Electronic Frontier Foundation, but in tax analysts, the setup was, there were some different categories, but certain, if I'm remembering correctly, the counsel's office, someone would say, I'm trying to decide this case and what legal rules should I apply in that case, and was asking within the legal office of its own agency, and that legal office had authority to tell people, here are the legal rules to apply in your case. And so that was a directive within the agency of, here's what you're supposed to do. If there is a directive within an agency about what you're supposed to do, that is the rules that govern the conduct of employees in that agency, that directive will be rendered by officials in that agency who may have consulted OLC and may do something that's consistent with what OLC said, but the directive they're giving will be given by people within the agency, and down to subordinates or horizontally within the agency. But the point that this court made in Electronic Frontier Foundation is that that's not how OLC works, and you can't say that's not how OLC works when it's doing one thing, but when it's none of the categories that the plaintiffs have identified here that make any difference in that respect. So they're really just trying to relitigate Electronic Frontier Foundation.
It just seems to me then what's doing the work is not that it's legal advice, it's whether it's operating horizontally or vertically.
I guess it's certainly not whether it's legal, it's whether it's advice. It's whether it's a directive to do something or whether it's advice. And if it's advice, even if it's advice that that you will follow, it's still advice.
In other words, it can only be a directive if it's vertical. It
right.
can only be advice if it's horizontal, is the way you see it.
I think that's the way the court looked at it in Electronic Frontier Foundation. I don't think this is a controversial point, though. Like if you have an agency general counsel's office and, you know, there's some policymaker who's trying to decide whether to engage in a particular policy, and they say to the general counsel, is this lawful or not? And the general counsel says, no, not lawful. Then the policymaker probably won't do it. It would be astonishing to say that's no longer attorney-client privilege, that's no longer deliberative, that's a final decision. That's just classic legal advice. Whereas if someone goes to the counsel's office and says, we're, you know, how do you want me to decide this question? And the counsel's office says, here's how you decide the question, then that's directive. And you know, OLC is similarly situated.
Okay. Thank you. Thank you, Mr. Tenney. It occurs to me that there's a cross appeal. So I think in fairness, Mr. Abdo, you should get 2 minutes for a rebuttal, or if you'd like.
Thank you, Your Honor.
Just very briefly, Your Honor, it can't be the rule that because a downstream decision could be made, that a policy decision that precedes a downstream decision is all of a sudden deliberative. That would allow the deliberative process privilege to swallow all of FOIA, and this court addressed that question in each of the past cases, Coastal States, Tax Analyst 1, 2, and Schleffer, and said, if the opinion is at the moment of issuance, the working law of the agency, that's adequate. Future deliberations over future decisions. So for example, in the opinion that Mr. Tenney referred to, the EPA, the dispute in that case was whether the EPA's policy that it had legal authority to issue fines was correct, or instead the DOD's policy that the EPA did not have that authority was correct. And the OLC said the EPA was correct. And so that then became the operative policy of both agencies. Of course, there are downstream decisions to be made following that policy, and those decisions might very well be deliberative. But the legal decision, the legal position of the agency was set at the moment that the OLC issued that opinion. And that's why that opinion and the others in the categories that we're seeking are either working law or final opinions upon their issuance.
Thank you. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 23-1155, Spokane Airport Board Petitioner versus Transportation Security Administration. Mr. McPhee for the petitioner, Mr. Lewis for the respondent.
Good morning, counsel. Mr. McPhee, please proceed when you're ready.
Thank you. May it please the court, counsel, and those in attendance. My name is Jim McPhee, and I represent the Spokane Airport Board. Now, this case involves a government agency that tried to amend a regulation without following the correct procedure. Now, airport operators aren't guaranteed an outcome, but they are guaranteed a procedure. And when TSA issued JEA 2301, it denied airport operators the statutorily guaranteed procedure of ratification by the Transportation Security Oversight Board, TSOB. Now, airport operators are required to have airport security programs by regulation. By separate regulation.
If I can just ask you a threshold question. Did the Spokane Airport Board raise this statutory question before the agency?
Yes, it did. In terms of adding cybersecurity as an additional topic to 49 CFR 1542-103A. Is that the question?
No, but the arguments that an emergency regulation had to be promulgated under 114 L2, right?
Yes.
And so requires approval by the TSOB.
Yes.
Was that argument raised before? Was that particular issue raised before the agency?
Yes, Your Honor, it was.
Can you point me?
Yes, in our petition for reconsideration, and that's at JA 144, in two different spots. At note 1, it states in 49 CFR 1542-103 entitled Content, TSA has developed a regulation for what each airport operator regularly serving operations must include in its airport program. That's a reference to obviously
I'm
1542,
sorry, I'm on the
103.
page, but where are you reading from?
JA 144.
Yeah, I'm on the page. So which paragraph?
Note 1.
Oh,
Footnote
footnote.
1. Now, if we go to the same page, JA 144, and we go above in the first paragraph, there's a passage in which Spokane Airport Board says, there is no clear legal or factual basis for TSA to assume regulatory authority over information technology assets of airports. That's a reference to first in note 1 that cybersecurity is not a topic listed in 103A, and that following that, TSA doesn't have the authority to regulate that absent rulemaking under 114L2.
But that, I thought the question was about, although I don't mean to hijack the question from Judge Rao, but I thought the question was about the last strand of the analysis on whether the TSOB needs to be involved in the process. And as to that, I didn't read either the footnote that you identified or the textual sentence that you identified to speak to that question or to fairly raise before the agency whether they needed to go through the TSOB process as if it were an emergency under Section 114.
Right, and Your Honor, I think that goes towards the issue of raising the 103 issue and the fact that they can't regulate cybersecurity. I think inferred in that is the fact that it has to go through a rulemaking process in order to do it. What the Spokane Airport Board had identified is the fact
But
that
even if it has to go through a rulemaking process, it just seems like that's several steps down the list. It's sort of like saying we raised one issue, and then if you follow that issue down the decision tree 7 steps, you'll see that that also would have encompassed that it needed to go before the TSOB. And I'm just not sure that preservation operates in that way, because the reason to have a preservation requirement and exhaustion requirement is so that the agencies put on notice that they need to address an issue.
and Your Honor, I would respectfully argue that when they issued JEA 2301 and the airport operators are given 15 days to draft their petitions for reconsideration, that it could be treated not unlike notice pleadings. I would also point the court to JA 162. Now, there was a memo that was drafted and given to the administrator of TSA. And another operator argued that TSA must amend its regulations before proposing cybersecurity amendments to aircraft operator standard security programs at JA 162. So it was something that was raised by, it was raised and it was identified by TSA to the point where it even went in a memo suggesting this is how we're going to respond to it. So I do think it was fairly raised.
Yeah, I mean, another question, I mean, we have some cases that suggest that that issue exhaustion is jurisdictional. The issue, exhaustion provision in the statute is jurisdictional, but the Supreme Court has in a number of recent cases said that an exhaustion provision is only jurisdictional if the provision is very explicit as to its jurisdictional nature. And the government doesn't suggest that there was an exhaustion problem here.
I would agree with that, Judge.
I mean, they suggest there's an exhaustion problem with a number of other arguments, but not the statutory argument.
Right, and they raise a number of different issues, which we addressed in the brief as it relates to potential waiver of different issues. But again, I think that note 1, read in conjunction with the other provision, fairly preserved it, in addition to the fact that TSA was aware of it as it recognized in its memo that I just referenced to the administrator of TSA.
Can you just say again, I'm sorry, on JA 162, which particular part of that JA 162 you're pointing to that just show TSA's recognition?
Yes, Your Honor, and actually, if I could grab my record.
Sure.
Your Honor, in JA 162, the lowest heading that's underlined says need to amend 49 CFR 144-103C to address cybersecurity.
Uh-huh.
This is the memo to the administrator of the TSA that identifies that cybersecurity must be added by rulemaking, not by ASP amendment.
Right, so it goes to that question, and that, I think footnote 1 that you pointed to earlier arguably goes to that question too, but then a follow-on issue about whether the process needed to involve the TSOB in a particular way. I'm not sure that that's flagged. There's a question of whether that's jurisdictional, which is a related issue, but in terms of whether it was preserved, the need to go through need to get to the get the TSOB's sign off, not in the way that was done, but in a way that's forecast by the section 114 provision, that particular part of it.
Your Honor, I think it's a guaranteed procedure under statute that if TSA is going to invoke and state that there is an emergency, then what TSA has to do is go under 49 USC 114 L2. They can do it without notice of comment, but just by virtue of the required statutory procedure, it requires TSOB ratification. It's just a required part of the steps if you're going to add cybersecurity to 103A.
They could just do a regulation with notice and comment, though.
That's correct. If they
So
did,
you
amend
just saying
the,
that they have to do a regulation doesn't necessarily encompass that they have to do an emergency procedure with TSOB. So you just saying they have to go by regulation could mean they need to have notice and comment.
well, what they would be doing is they've stated that it's an emergency, and as a result, they can forego notice and comment in that emergency, yet it would still have to go through
No, I
TSOB
understand that, but
ratification.
that's not what was preserved, is it?
I believe that it was, because I believe that the statutory procedure is guaranteed, and once the issue is raised, then the guaranteed statutory procedure has to be followed. So we're required to have our airport security programs are required by separate regulation to have 21 specific topics, but one of those topics is not cybersecurity. Now,
So looking at footnote 1 on page 144, it says that the process followed without notice and comment, it's legally deficient, and it shows callous disregard for the value to be provided by comments from airport operators and aircraft operators and review of the same by TSA. So it doesn't seem to be saying, if you're going to do an emergency, we get TSOB. It seems to be saying you needed to get comments because you're disregarding the value of comments.
well, Your Honor, Judge, I think that the combination of note 1 and the text above, coupled with the memo to the administrator of TSA, does properly preserve this. And what it does is it triggers a guaranteed statutory procedure, the end of which is TSOB ratification. Now, if TSA wants to amend 103A to add cybersecurity, it has to go through that procedure and it has to get TSOB ratification, but because it didn't, this agency action expired after 90 days. Now, TSA responds by cobbling together patchwork of statutes and regulations, for post hoc support for an overbroad and an incorrect assertion that it inherited all of FAA's functions. Now, but they pirouette around the statutes that actually control, and it's right in front of us in black and white. Now, Congress did give FAA emergency rulemaking ability without notice and comment. But when TSA claims that Congress then transferred that FAA function to TSA, it's incorrect. Because emergency rulemaking without notice and comment is at 49 USC 46105C. Now, when ATSA was enacted, we had 46105, it had subsection A, ordinary rulemaking, and subsection C, emergency rulemaking. Both listed FAA. But when ATSA was enacted, TSA was added to ordinary rulemaking in subsection A. It was not added to emergency rulemaking. That was
My
retained
question-
exclusively by FAA.
My question is, does that matter? Because the grandfathering provision, 141F, says that the TSA may exercise all authorities under any other provision of law that were available with respect to the performance of the function for the performance immediately before the effective date.
And that provision, that savings provision, and that any portion of the savings provision, but that specific portion of the savings provision doesn't help TSA at all. Because as you just stated, that savings provision allows TSA to perform functions that were available to FAA, both before and after ATSA. And to this day,
But this just says
4610
before. This just says as of the date. So if FAA could do it before it was transitioned to TSA, why can't TSA still do it, even if things changed after?
well, Judge, my reading of that is they were transferred things that were available to FAA. But 46105 emergency rulemaking without notice and comment is available to FAA to this day. And in addition, the savings provision gave TSA functions that were transferred by ATSA. But as I just mentioned, when ATSA was enacted in
I understand your
2001,
argument. It's just not clear to me that this provision doesn't allow TSA to exercise those functions anyway, because it says that if they were available immediately before the effective date, TSA can do it. So even if you change it after, it's not clear to me why they can't still perform those functions that existed before.
but our reading of that statute is that if the functions were available, meaning that they were transferred to TSA and ATSA, then TSA can perform them. But these were not transferred in ATSA. The 46105C emergency rulemaking without notice and comment was before and after ATSA, and to this day retained exclusively by FAA. And the savings provision also doesn't help, because when TSA cited its authority for JEA 2301, it didn't cite the savings provision. It cited 49 CFR 1542 105D, and 105D doesn't cite the savings provision.
And so, and where does that take you? So suppose the legacy FAA authority isn't what's at issue, and that, let's just, I know the government will resist this, but just for purposes of understanding where your argument goes, if that wasn't or couldn't be what was exercised here, then what?
If you could clarify, Chief
Yeah.
Judge, if what wasn't available.
If the legacy FAA authority isn't what was being exercised, I think it's if I'm understanding all the numbers being bandied about, and I confess that I'm not sure that I am, but if I'm understanding all the provisions that are being bandied about, I thought what the exchange that you were having with Judge Pan was about whether the carryover FAA authority was what was being used to promulgate the 2301.
No, the 46105C, which is FAA's emergency rulemaking without notice and comment, wasn't referenced in JEA 2301.
Right.
And again, that was retained at all times with the FAA. Now, if you're talking
you're-
about
so then-
emergency,
Yeah, so I guess I think we're saying the same thing, I believe, which is that, so the government relies on the FAA authority, but you're saying that wasn't relied on and it can't be relied on, right?
correct. If you're
Right.
talking about emergency rulemaking, FAA gets to do it without notice and comment under 46105C, but TSA needs to do it under 49 USC 114L2, and it requires TSOB ratification, which makes complete sense. Because FAA had been doing emergency rulemaking without notice and comment since 1958. And in
So,
2001.
I guess what I'm asking is the consequence, if we were hypothetically to agree with you that the agency didn't or couldn't rely on the FAA provision, but had to go under the TSA provision, what's the upshot of that for you? Is it that then the joint EA couldn't be sustained because the TSOB ratification was not obtained? Is that the
Yes.
ultimate upshot?
Yes, and what's interesting and important to note is the fact that had TSA done this correctly, that TSOB wouldn't necessarily be looking at JEA 2301, because to do this correctly, you'd have to add cybersecurity to 49 CFR 1542 103A as a 20-second topic.
Okay,
So
so
had this been done-
then on that, suppose we disagree with you on that. Suppose we think that for purposes of the regulations, and I'm just speaking for myself here just to play out the decision tree. For purposes of the regulations, let's suppose we think that 23-01 didn't need to be an amendment to the regulation you just identified, which spells out what needs to be in the security program. And it could still be good. Then what? Does that mean, then did it, if we think it's consistent with the regulation, and does that mean then that the TSOB ratification requirement that you otherwise think would be operative then drops out of the equation?
So is the Chief Judge, is your question that this JEA 2301 truly was only an ASP amendment and was not rulemaking in any way?
Right, it was a
Didn't change
valid,
any other
exactly.
regulation?
Exactly. It was a valid, let's just suppose we think it was a valid ASP amendment.
Then TSOB ratification would not be required, because under that hypothetical, then 103A, it wouldn't be a rulemaking and changing the regulation under 103A. We'd have to ignore the fact that TSA is trying to add an additional regulation, an additional topic to that regulation. And if we can, suspend belief and say that that's true, then they could have proceeded without
And
TSOB
and
ratification.
103A is what? What's the full site for that? Where are we at?
49 USC.
That's the reg.
49 CFR.
Got it.
1542, 103C.
Okay, got it. Okay, thanks. Yeah, so in your view, if we think that that JEA, so many numbers, JEA 23-01 could be an amendment for purposes of the regulations, you resist that. But if we thought that, then your objection as to TSOB ratification drops out.
Yes,
Okay.
but our objections with regard to being able to show prejudice and being able to show that this agency action was arbitrary and capricious stand, both of
Got it.
which are justified by the failure to follow the requisite procedure, as well as the additional points that we raised about, for example, aggregating all airport security programs, in one spot, which is a risk to cybersecurity. I mean, if you're going to take all of these airport security programs with the sensitive cybersecurity information and put them in one spot, it's not only a risk, it's a challenge to cyber terrorists. We're going to put them in one safe so you have one lock to pick instead of dozens of safes.
Mr. Rafik, what is, I'm interested in your response to the TSA's argument that they have been basically exercising this kind of legacy FAA emergency authority since really the agency was created, and they've never even convened the TSOB for the purpose of ratifying an emergency regulation. What should we make of that? I mean, how
Well-
should we understand that argument? This is sort of a long-standing and contemporaneous understanding of the TSA.
It's whereas maybe the first example might date back a ways, it is not long-standing and it's not ongoing. And it's not enough to excuse TSA of the requirement to follow the statutory procedure. I mean, were these instances emergencies? And in fact, were these instances circumstances where TSA just got it wrong and it wasn't challenged? I mean, I don't know that, but what I do know is that there is a statutory framework and a guaranteed procedure. Again, airport operators not being guaranteed an outcome, but being guaranteed a procedure that wasn't followed. Perhaps it wasn't followed there.
Has your client been subject to other emergency regulation type procedures that followed the procedure that was followed here?
Subject to something separate and apart from JEA 2301.
Yes.
I'm not
I'm just
aware,
wondering how often this happens.
I'm not aware of any off the top of my head in terms of a joint emergency amendment. There was a national amendment, August 11, 2022, that TSA put out with regard to cybersecurity, but that went through a round of notice and comment. And when the second round of notice and comment was coming up, that's when JEA 2301 was issued.
So this is the first instance that you're aware of where the TSA followed this procedure to implement what is essentially a regulation.
I'm hesitantly answering yes.
My colleagues don't have additional questions. We'll give you a little bit of time for rebuttal.
Thank you very much.
Mr. Lewis?
Ben Lewis for the government. As the case comes to this court, there is no dispute that there was an emergency in the aviation sector that the TSA needed to address foreign states, their proxies and cyber criminals had repeatedly conducted cyber attacks on the aviation sector, and TSA had identified cybersecurity vulnerabilities in airports that called for an urgent response. And so accordingly, TSA issued an emergency amendment to airport security programs.
So why did TSA do that instead of following the procedure in 114L2?
So I think it would be useful to walk through exactly what the government relied on and what TSA understands itself to rely on. So the substantive authority that, and the reason why it went through the regulations is because for airport security programs in the aviation sector, it typically exercises this kind of emergency authority. The reason why, emergency amendments for airport security programs.
And have they done this before for a regulation type amendment?
Yes. So there are dozens of emergency amendments, both on airports and aircraft, that amend their security programs and go through the procedures of Section 105D. The reason why they did that.
Can I just clarify, when you say there are dozens, where it strikes me that this often would apply in an individual basis, like
Yes,
TSA identifies a particular airport, you need to fix this, but you're saying there are dozens that were regulation type things that applied to a vast swath of airports.
Dozens that are broad-based, that are not within the existing categories of subject matter. And that's because TSA is at the front line of these emergencies that arise from time to time. If you refer to the 1972 advisory circular that accompanied the initial regulations, they're quite directive and they're quite specific about the kind of substantive requirements that airports need to follow. If you follow that through to the other authorities we've referenced in 1985, when there were airport hijackings, TSA was at the front lines of those and required emergency amendments in response from both aircraft and airlines. You follow it through to the 9/11 itself, when there was an emergency amendments that did things that we now take for granted, but did not exist at the time. For example, no longer allowing curbside check-in, requiring passengers to go with a ticket through security screening, requiring that vehicles not be within 300 feet at the time of an airport. All of those things are substantive activities that they pursued through the mechanism of emergency amendments, and the same is true here. But I do think it would be useful to clarify exactly what the government is relying on here, because I don't think the other side gets this exactly right. And so in November 2001, much of the point of the Aviation and Transportation Security Act was to go very quickly from an agency in FAA that had responsibilities over all aspects of administration for the aviation sector to one that was dedicated to aviation security in particular. And the way that it did it is through primarily this savings provision. So FAA had long been responsible for airport security programs. And so Section 114F11 of ATSA makes clear that it's going to be TSA's function to, quote, oversee the implementation and ensure the adequacy of security measures at airports. FAA had longstanding rules and regulations to carry out that function. And so the congressional judgment at Section 141B and F of the public law was to say those rules and regulations carry on through, according to their terms, wholesale to the TSA. And so it's those authorities that TSA is relying upon. There's no Chenery problem here. When the TSA initially passed these regulations to itself, it cited a broad range of authorities, including 49 USC 44901. That's where this public law is codified at the note to that section.
Where's that? Where did it cite that provision?
So it's the other side references the regulations that carried out the administrative action of taking the regulations from FAA to TSA. The authority for Part 107 of this section, but Part 1542 of this section. In that section, it cites essentially all of the provisions that were passed through, both in Chapter 449 and in the existing regulations. And in that section, I take the other side's argument to be that because TSA cited 114 at that time, that when it exercises that emergency authority, it's going through 114L2. That's not the case. It cited that provision because it's carrying out the functions that it became responsible for to oversee the adequacy of security measures at airports.
Mr. Lewis, why does the savings provision apply here, though, right? Because the savings provision has to be for a function that's transferred to TSA. And 46105C, which is the emergency rulemaking, wasn't transferred.
Yes, so the function that TSA is taking on is the function of ensuring the adequacy of security measures at airports. To be clear, the government is not saying that it needs any special emergency rulemaking authority to take an action immediately and is not relying on 49 USC 46105 to say that it can take this action because of that provision.
Well, I understand that that's not what you're saying, but in order to take the FAA's emergency rulemaking and use that by the TSA, you have to have some underlying statutory provision to support that emergency regulatory authority.
Anytime an agency has substantive authority, it can decide to take an action in 7 days, in 14 days, or immediately. The disputes in those cases are about procedures, and typically it's a dispute about whether an agency follows the Administrative Procedure Act, including notice and comment provisions. The other side has been quite clear in page 15 of their reply brief that they are not making an argument anymore that TSA did not go through notice and comment, that they're not relying on that or making an APA style argument. And so I really think the dispute here for the court is, did TSA act appropriately and just following the procedures in 105D, or did it need to take the additional measure of getting TSOB ratification?
Congress specifically, specifically provided for a way for TSA to do emergency rules. And it does seem, or I guess my question is, why is it not an end run around that provision to make emergency rules in a different way, other than the way that was prescribed by Congress?
Right. Agencies all the time have many different mechanisms to take an action immediately. It can do, as the other side recognizes, an interpretive rule that takes effect immediately. It can do a rule that operates through the good cause exception of the APA, or it can act through.
TSA is not relying on those.
I think TSA does understand what it is doing here as operating quite similarly to the good cause exception under the APA. But to answer your question, the reason why Congress would set up these two different mechanisms for TSA to operate is that they further different functions of the statutory design. So one half of the purpose of the Aviation and Transportation Security Act was to ensure that there was an agency that was dedicated to aviation security, and at a time of great uncertainty, in mere weeks and months, could take those regulations wholesale. The second half was to ensure that there was an agency that could regulate all aspects, modes of transportation. And
how does that, I mean, I understand how important the TSA is, but how does that relate to this rulemaking authority?
It relates to this rulemaking.
I don't see the connection.
Yeah, the connections, I think it roughly corresponds to the two functions of these tools for TSA. The reason why Congress gave TSA the 114, this tool in 114 to go through notice and comment is because it wanted to give them a much, much stronger and much, much broader mechanism to effectuate change than had existed before. And so to give a concrete example.
Wait, I'm sorry, I thought you said it did exist before because you're relying on the FAA legacy ability to do things with no notice and comment.
I'm trying to distinguish between two different tools that are available to TSA here. One is the 105D mechanism, the congressional judgment that TSA is relying upon there to exercise that tool is the public law in ATSA itself, section 141F and 141B. To answer the question of what procedures was TSA required to go through, that congressional judgment that those rules and regulations be made available to TSA governs.
Is that, there's just so many numbers being thrown around here, I'm getting confused. Is that the FAA legacy authority?
Legacy, it is the savings provision in ATSA.
Okay, but the effective savings provision is to allow TSA to rely on what the FAA was relying on.
Correct, to do
Okay,
exactly
that's
the
what
same.
I'm just going to call that
Yes.
FAA.
The FAA,
Okay.
but I just want to distinguish that from the Section 105 FAA authority that the other side has been referring to.
I thought, what's 105?
Sorry, 1005.
1005, okay.
Yeah,
'cause
49, yes.
49 USC 46105.
Right,
is-
is that, the government relied on that provision to make the very narrow point that when these rules and regulations were initially promulgated, Congress understood that the airport security programs would not have to go through notice and comment. It's not relying on that provision to say that anything I think about TSOB ratification one way or the other.
We'd say that provision, we're not talking about 46105. 49 USC 46105.
Correct, that provision.
But and then what 1005 is not 105.
Yes, there's the Section 1005 of the FAA Act.
Which
Is the
is-
same thing was codified at 49 USC 49605, sorry. But I'll,
105, okay.
What does 1005 say?
1005, so sorry, 1005 is the existing tool that FAA had to take immediate action in response to an emergency. It's
Without notice and comment?
correct. It is the statutory provision. And then
And
the,
what-
Everybody
why-
else is referring to that as 1005.
yeah, I
so-
apologize, yeah, for confusing, causing confusion.
And on, let's call it 1005. I thought at one point there was a reference to 1005D. But when I look at 49 USC
105D, yeah, sorry.
105D,
Yeah, sorry, go ahead. Yeah.
I don't see a 105D. I see 49 USC 46105 has A, B, and C. Is there also a D?
Yes, yes, in the, I mean, maybe I have my, look at the,
Yeah, D is emergency amendments.
yes, sorry, it's available at, I think,
Under 49 USC 46105,
1542.105D.
1542.105.
yes,
So that's a
yes, sorry.
regulation. That's a regulation.
That's the
not a
regulation.
statute. Okay.
Sorry.
So that's what the 105D you're talking about is a regulation.
Correct. It's a regulation and the congressional judgment that explains why TSA has this regulation available to exercise it is the savings provision in ATSA. I
But
think.
you haven't explained why the savings provision applies here. Because those functions haven't, I mean, you're just relying on the general functions that are transferred to TSA. But the savings provision seems to be referring to specific authorities that are transferred to TSA.
Yes, these specific authorities. I think it's important to recognize that the tools that we're talking about here are quite different in kind. The 105D, this emergency, is there another way I can be helpful to refer to it?
105D is a regulation.
Yeah,
I understand which one you're-
the regulation, it requires, its amendments take effect only upon notice. And there's an administrative back and forth that happens with these petitions for reconsiderations. That is not the case when TSA exercises the tool in 114L2. In that circumstance, the rules take effect without notice, and there is no opportunity for an administrative back and forth. And so to give an example, on 9/11 itself, there were thousands of airplanes who were in the air. FAA issued an order that grounded them all immediately. That took effect without notice and was enforceable immediately. There was no opportunity for a back and forth. Then in the weeks that followed, the FAA issued an emergency amendment that directed the conditions that were required for airports to reopen. They were collaboratively with airports in order to get them to a place where
So
airports could be made
I
available.
understand that these two provisions operate in a different way, the regulatory authority and the 114L2
Yes.
authority. They operate differently, but that doesn't answer my question about where the authority comes for TSA to exercise FAA's legacy regulatory authority.
FAA's, the regulatory authority, we understand that authority to come from the savings provision.
Yes, but why?
Because that is what Congress said. Congress directed that these quote rules and regulations would continue in effect.
Regulations, right, but for functions transferred to TSA.
Correct. And the function that was transferred to TSA is this responsibility to oversee the adequacy of security measures at airports. Everyone had understood, Congress included, and was specifically aware of at the time.
That's the substantive function. The function to make emergency rules was not transferred.
And the government does not understand there to be required authority to take an action immediately. When it takes an action immediately, but agencies take actions immediately all the time. There are disputes.
Wait a minute, though. Wait a
You're
minute.
relying on the FAA legacy regulation as the authority for what you did here, what the agency did here.
We're relying on the rules and regulations, and then there's a procedural dispute over whether TSA needed to do more than those procedures in the regulations.
Let me ask
Yeah.
it another way, because I think I have the same question as Judge Rowe. You're relying on the savings provision, and you're saying that the power and authority of FAA to regulate safety and all these things were transferred to TSA.
That's substantive authority, yes.
And I thought I heard your friend on the other side say that since 1958, FAA was issuing emergency rules with no notice and comment, that that's something that it's allowed to do. Is there a statutory provision that allows it to do that?
That allows TSA to,
FAA, the legacy provision from 1958, they've been doing this.
yes, there's,
What's the basis for FAA doing it?
yeah. So in addition to their ordinary APA tools, I think that they have this specific statutory provision at 49 USC, I believe it's 49605, but in,
But
yes.
there's
Isn't there
no
emergency rulemaking authority in 46105C?
Yes, it is. Thank you. Yeah.
And
it's-
that provision, this is what I'm asking, that statutory provision was not transferred to TSA.
Correct.
46105A was transferred, but not 46105C.
Yes, we don't understand, we don't think TSA needs that authority to have been transferred. And it is, I think it is true that if the other
It
side,
needs that authority to be transferred if you're relying on the savings clause.
I don't think that's true.
Okay, why?
Yeah. Because it has, the savings clause makes quite clear that TSA has the substantive authority to issue amendments to security programs, and there is no special authority that is required for it to take that action immediately or to do so in the procedures that are outlined in 105D. There may be, in many cases, procedural disputes or issues or arguments that can be made. But I don't understand the other side to be making an argument that TSA, that this whole system of airport security programs, that they lacked the authority to issue amendments. And if they were making that argument, I think that is an argument that they would have to be presenting to the agency in the first instance, because that would be an argument that what TSA did here, the emergency amendment it took, was not authorized.
Let me ask you about that, because the government here says that a number of issues were not exhausted, but it does not argue in its brief that the statutory argument was exhausted. In fact, it provides a lengthy rebuttal in the red brief.
Yes, the reason why I did that is because the regulated entity is informed of whether or not it goes through TSOB ratification at the time that it receives the denial of the petition for reconsideration.
Has the government waived any objection to issue exhaustion?
We haven't taken a position, and if this court, understands it to be jurisdictional, it would,
I
have to
understand if
analyze
it's
it.
jurisdictional, of course, you can't waive it, but if it's not jurisdictional, then it does seem to be waived.
I'm not trying to affirmatively waive it here at the podium, and we haven't taken a position on that question. I think there is a conceivable world where this
Well, you
court.
haven't argued issue exhaustion on the statutory question at all.
Correct.
So you have forfeited or waived it.
Correct. We don't take a position on that question. And the reason, I think, is because they received that notification about whether or not it goes to the TSOB ratification process at the time of the denial. But if I could give maybe.
I don't understand that. Why would that be a reason not to raise? I'm
So
missing.
the opportunity for them to raise an argument with the agency is through this post-issuance administrative petition for reconsideration. And at that time, it's a 14-day period. There's a 30-day period for TSA to go through the TSOB. So at the time that they're filing their petition for reconsideration, they don't know yet whether the TSOB has ratified it or not. So it's true here that TSA, when it issued Joint EA 2301, that it noted the authority it was relying on was the regulations. So I think, these sophisticated entities would know that it was not probably going to go through TSOB ratification, as that has been the longstanding practice for the agency not to do so. But we didn't formally take a position on that in our briefs. And I'm not trying to, spin out a new argument here at the podium.
Right, but suppose we take note of the fact that the regulated entity didn't object to the agency, that the agency failed to get TSOB ratification. Do you think that would be wrong to care about that?
I guess it depends on the form that their argument is taking. I think it matters a great deal if they are kind of making the argument here that TSA lacked the authority to issue an emergency amendment immediately through the procedures of 105D. If that's the argument they're making, then they do need to present that to an agency in the ordinary course, because as soon as they know that they're issuing an emergency amendment under that regulated regulation, then they're on notice that they should be making an argument that the agency lacks authority. If they're making what I had understood their argument to be, that in addition to the procedures and the issuance of the emergency amendment, TSA needed to then get it ratified by the TSOB, I think that type of argument, it's fair for them to raise, in the first instance in a petition for review, because they don't have that opportunity to know either way until the petition for reconsideration is denied. But if I could maybe give an off-ramp to the TSOB issue, I think that has come up here today. The other side does seem to clearly concede that if the regulations, if the emergency amendment was within the regulatory authority and does not require an actual published amendment to the regulations, then it would not need to go through the TSOB ratification. I think you can take the parties' arguments on their terms, and there are a couple of clear reasons why I think this is an amendment and not a regulation. One is...
Can I just, before you go there, because I do want to hear that.
Yeah.
But on the predicate to that, which is that if it is an amendment, then TSOB ratification drops out of the equation. You agree with that?
I agree.
What you're saying is that they've conceded that.
Yes.
And I'm wondering, does the government agree that that was right to concede
that? Sorry, can you reframe the question just so I have
it
maybe,
right? And tell me if I'm asking the wrong question.
Yeah.
But what I understood you to be saying is that the other side concedes, and we heard what the exchange earlier, that if JEA, whatever the number is, whatever the one we have
yes,
before, if that one was within the amendment power under the regulative 105D, then there's no available objection that the process needed to include a TSOB ratification that wasn't gotten.
So I think, there are a lot of premises baked into, I think, that concession, and I think it is appropriate to take their argument on its terms. I think the general concern or the gist of their argument here is that 114L2 was meant to displace this authority in 105D. And to the extent that it's an amendment and not something that they understand had to be, where the agency had to change its published regulations, then I think you could take that argument to be that there's no potential conflict between those two provisions. The way we would understand that argument, I think, is that the savings provision says that the procedures should continue by their terms, and nothing in 114L2 modifies those procedures. They are presenting an argument that it appears that it modifies those procedures only if it is not an amendment. And so I just think you can resolve the dispute on those terms. And so turning to whether or not it is an amendment, I think clearly this is something that can be conceived as an amendment. If in ordinary contract negotiations, if one party may say, I have an amendment, I would like you to make this change, and I won't approve it otherwise. That is precisely what TSA is doing here. It's saying, it's expressing the conditions for its approval through the emergency amendment that it needed to issue immediately, and doing the same type of thing that, anyone would understand would not need to go through a formal kind of regulation. I would also say that it would make little sense for, I think as the other side seems to suggest, for every kind of amendment that takes this form to have to go through, be published in the Federal Register, and kind of take its place next to the other applicable items. Again, this tool is designed for circumstances in which the TSA is confronting yet unknown threats. And so the other side seems to suggest that the existing regulations bind TSA only to the kinds of threats that is already expressly considered by regulation. That doesn't seem to be a very sensible approach to me. And just as a matter of practice, I think, again, I would refer you to all of the materials that we've cited on our brief to how TSA has understood its own regulations to have often very substantive expressions of the necessary approval requirements from the 1972 advisory circle all the way through to these emergency amendments. In all of those circumstances, TSA has not understood it to be required to amend the regulations in order to issue an amendment to the airport.
When you say approval, you mean approval of a security program?
Correct, yes.
And so I guess the question on that is, the way the regulations are framed, I'm not saying this means that doing this as an amendment is off the table, but what specifically seems to be contemplated by amendments is amendments to a particular security program that a particular airport or particular aircraft might have. This one speaks more broadly. That's not to say it can't be done that way, but it does seem like that's the heartland of it.
I agree that that's their position, that TSA needs to individually redline airport security programs in order to effectuate policy in this area. The regulations do not require that. And I think it would make little sense for TSA to bind itself to not being able to say when there's an emergency that is equally applicable to all major airports to at one time issue an amendment to those airport security programs.
I mean, that makes functional sense to me. So, I mean, I take it the bottom line for the government is, look, I mean, in theory, you could do an amendment that applies, you could apply an amendment to every single individual security program.
Yes, and TSA has done that.
That's what this does.
Correct, and that's what it actually, for this one, it only applies to certain categories of airports that are quite large, but
those categories. But as to those, the functional upshot, recognizing that it's a subcategory of all airports, but as to those and aircraft, but as to those, it's the equivalent of adding requirements to what's otherwise already in 103 for what a security program needs to contain.
Sure. I don't think there's any doubt that sometime TSA will encounter new subject matters and it needs to, in the face of an emergency, take an immediate response. I mean, we've cited, to the extent their argument is that the regulations itself constrain the agency, we've explained that those are not meant to be exclusive and that the kind of relevant definitional phrases indicate that they're not meant to be exclusive. And I just don't think there's a case to be made that TSA which traffics in ongoing and unknown emergencies, would require itself to go through a burdensome kind of pre-planning a process rather than give itself the flexibility to issue an amendment when an emergency arises. If I could just try to take one more stab at, I think, clarifying why I think the text is pretty clear on the 114L2, that if you do reach that question, I do think that the statute speaks to this in quite clear terms.
Which statute?
So this is 114L2.
No, but when you say the statute speaks clearly,
49 USC 114L.
114. Okay,
Yes. That statute, the most straightforward reason why TSA did not exercise the tool in that statute, why it doesn't apply here is that TSA did not understand itself to be exercising any mechanism in 114L2. 114L2 is a tool that allows the agency to issue, to take a regulation and issue it without notice and without any further administrative back and forth. And the language of the provision, this is L2B, says that TSOB ratification will only apply to a regulation or security directive that is issued under that section.
You're suggesting what the agency did here is more protective of public rights because there was notice.
It's absolutely more protective of public rights, and it's absolutely true that I think the collaborative process here with the airports helped improve the emergency amendment in a way that would not have necessarily been the case otherwise. But I think the greater point is that Congress passed a belt and suspenders statute that gave multiple mechanisms. One applies in the aviation sector, one applies across all modes of transportation. You're faced with it kind of the dispute on this issue is essentially with respect to this bigger authority, whether the condition to the bigger authority also applies to the smaller one. And Congress can decide whether or not it cares about that overlap. It decided in this circumstance that I think that TSOB ratification is appropriate only for 114L2. That makes perfect sense because it is the type of broad and strong authority that would warrant TSOB oversight. We're talking about an order to transportation entities that would not just say all flights are grounded, but says all trains, all pipelines, all transportation entities are grounded, a top-down directive, and there's going to be no administrative back and forth here. In that type of circumstance, it makes absolute sense for a seven-headed board of other agencies to be consulted on national security matters. But I take the other side's position.
I'm sorry, TSA could use L2 in the manner that with a back and forth, because, for example, it applies to security directives, so not just regulations. And why couldn't TSA say, we're issuing a security directive, which is going to require all airports to submit an updated safety program that accounts for cyber terrorism, and that will be then approved by TSA?
So the security directives, as I understand them, are temporary directives that don't work exactly through the same process and authorities. So I wouldn't treat them as one and the same. But
security directive is a term of art that doesn't apply to this.
It is a term of art in this area. I don't want to make too much of that, but I think our basic point is that there may be some overlap between what TSA is able to do through these provisions in the aviation sector, but the existence of that overlap is not surprising given how broad the 114L2 authority is. And it's important to note that if there is some overlap in the Venn diagram, that there's also extensive periods of non-overlap on both sides. On one side, there's the other modes of transportation through the 114L authority. And on the other side, you have, I think, quite tailored and quite narrow emergency amendments that are only meant to apply to a subset of airports where it would be deeply surprising to expect that Congress wanted this super governmental body to micromanage this collaborative and iterative back and forth between.
So is the upshot of that are you saying that 114L2 couldn't have been used to do this, or are you saying Congress wouldn't have required it to be used to do this?
Sorry, say the two options again.
Well, are you saying that 114L2 is something that could not have been used to do the exact same thing that was done here? Or are you saying it could have been used, but Congress wouldn't have required that to be used? It would have allowed the method that was used to be used as another way of doing it.
If TSA had used the 114L2 authorities, it would not have paid the prices in the regulation, namely the petitions for reconsideration that leave TSA open to APA challenges based upon its agency explanation, the fact that it only takes effect upon notice. I'm not standing here to say that TSA could not do something through the 114L2 authority that would further its policy objectives in a similar way, but I don't think that's any different from TSA having, or agencies having the option to go through adjudication versus rulemaking.
Then it sounds like you're saying that 114L2 could have been relied on to do the exact same thing.
It wouldn't be if they did it, it wouldn't be the exact same thing. It would be in that type of circumstance, there would be no administrative back and forth between the
Procedurally, but substantively, you could not do substantively the same thing?
yeah, and because it's a procedural dispute here. The substantively,
But what I'm asking is substantively, could you do the same thing could you substantively do the exact same thing through 114L2, granting that would be a different process to get it done?
meaning TSA could have issued a requirement that tells, that has access controls, segmentation policies, and does so through a 114L mechanism. If it issued the requirement that way, in that type of circumstance, there would be no administrative back and forth, and that would take effect immediately. TSA has done that for other types of transportation. So there's references in the administrative record to pipeline, there's references to rail. In those circumstances, they don't have this legacy authority, and so they issue those regulations immediately. There is no back and forth with the regulated
And
community.
why can't they provide for a back and forth under 114L2?
They can. I mean, certainly they could. If the agency, but I take the other side's argument to be actually that they couldn't. That they either have to do 114L2 or it's
No, my
not within the
question is just, and I don't know that it's important, that can you replicate exactly what happened here, including the back and forth under 114L2? By saying in your L2 directive or regulation that there will be back and forth.
Yeah, it wouldn't be exactly the same because again, you would have this difference in when the regulation took its effect. But again, I'm not trying to stand here and say that there's not a quite similar thing that they could do, or that what it did through an emergency regulation is ultimately, so widely different from what you might expect the agency to do under 114L2. The point here is that this was a belt and suspenders approach that was passed in November 2001. And the mere fact that there is some overlap between these provisions tells you nothing about whether Congress intended for these TSOB ratification procedures to apply in this narrow overlap that really only takes place in the aviation sector. I think Congress can decide whether or not it cares about those overlaps, and the text is really a complete answer to this question because it says that TSA doesn't need to get TSOB ratification when it doesn't exercise the tool in 114L2. TSA didn't understand itself to be exercising this authority, and really it did something that is different. Now, for better or for worse, that may raise other problems or other issues or other disputes that other petitioners can bring and present to the agency about the authority that TSA has, but it really says nothing about the scope of TSOB ratification. The text, I think, is a complete answer to that question, and it would be quite strange just to take a step back to go from a circumstance in which the FAA had a litany of tools in both the APA and its FAA authorities to one in which I think the other side is quite clear. It thinks TSA had one option, its most powerful medicine at all times, and had to use it. It would be strange for Congress to single out TSA in that fashion. And
the one that's the most powerful medicine is which one? That's
114L2.
Okay.
Because of, yeah.
So because it can do it immediately and it immediately takes effect and all that.
And then it applies to all modes of transportation.
Not non-limited to aviation. Yeah.
Correct.
So can I just ask this question just so I can keep track of
Yes.
where the government's making a non-preservation objection and where it's not?
Yeah.
So there's this question that you've just had a helpful back and forth on about the potential use of 114L2 versus the other route to go, which the agency under the government's perspective was what was adopted, which is going through I'll call it FAA legacy route, but
Yes. Yeah.
If that captures it, great.
Sure.
Through the savings clause.
Yes.
And has the government made the objection that the challengers' notion that this needed to go through 114L2 rather than through the savings clause route, has the government objected that challenge wasn't preserved before?
I didn't understand the other side to be making an argument in their brief that the amendment is invalid because it went through the procedures of 114D. They knew that TSA was going to go through the procedures of 114D. And if they are presenting that argument that TSA had to, that it was unlawful for them to exercise a tool that was not 114L2, then that argument is not preserved. It needs to be presented to the agency. To the extent they're making it for the first time at the podium, we would urge this court to reject it. What we think that the argument that TSA needed to take an additional procedure beyond what is in 105D, that it needed to, after it finished the administrative back and forth, it needed to get the amendment ratified by TSOB. We think that they are essentially put on notice of whether or not the agency goes through TSOB at the time that they get a denial of the petition for reconsideration. And so they can raise that on a petition for review in the first instance. If there are no further questions.
All right, thank
I'll
you.
start with
Thank you.
Thanks.
Mr. McPhee, given the length of the back and forth, we'll give you 3 minutes for a rebuttal.
Thank you. Now, Your Honor, with regard to Spokane Airport Board's concession, you just referenced 49 CFR 1542.105D in conjunction with the concession. I want to make sure that the airport's concession, we're on the same page and have the same understanding. So if this court finds that JEA 2301 was amending an ASP and it was not engaging in rulemaking, then I would agree that TSOB ratification wouldn't be necessary. But JEA 2301 does amend a regulation. Now, the airport's not taking the position that TSA can't amend airport security programs. They can, and they can do that under the regulation at 105D. It allows them to amend airport security programs, but it does not allow them to amend regulations. And that's what they did here, because 103A, regulation 103A, doesn't list cybersecurity. And TSA is attempting to use an airport security program amendment to actually amend 103A to add cybersecurity. Now, it's true that the airport could do more in their airport security program, but TSA can't require more because the regulation at 1452.103A, that's a ceiling for them. They're telling us what is absolutely required to be in the program. And it doesn't make sense to say, this is what's absolutely required in the program, but in the airport security program, but maybe there's more, and we'll tell you later. This is a list of what is absolutely mandatory to be included in the airport security program. So if they could just add topics, the question becomes, where do we draw the line? And could they add an additional topic of labor disputes? And then they're going to infringe upon the National Labor Relations Board, just like here, where they're just adding a topic of cybersecurity. And then that's going to infringe on the Cybersecurity and Infrastructure Security Agency, which is America's cyber defense agency. It's responsible for cybersecurity across all levels of government. So the real concern is where the line would be drawn, if at all.
I'm just trying to understand what argument you're making so we can decide whether it was preserved or not. So are you arguing that TSA did not have authority under 105D to do what it did?
Yes.
And so that is what your friend on the other side, Mr. Lewis, says that you didn't argue.
But, as I discussed earlier, we did
Okay.
preserve it in footnote 1 and in the body of it, saying that there is no factual or legal support for TSA reaching in to try to control our information technology.
And are you arguing that the only route they could have taken was to go through 114L2 to do what they did?
Add cybersecurity as an additional topic to a regulation. To amend that regulation on an emergency basis, TSA was required to go through 49 USC 114L2.
So those are your arguments. They
Yes.
had no authority under 105D and they had to go through 114L2.
Yes.
And then just to put a bow on the concession question, and thank you for clarifying this. If hypothetically, we were to conclude that under 105D, the agency could do this, you've presented a forceful argument as to why they couldn't, but if we conclude that they could do it under 105D, then the TSOB ratification question drops out in your.
Well, that's not a concession that I would make, because that sounds to me like I would be conceding that under 105D, that TSA can amend an ASP and effectively amend a rule, and I would not concede that. My concession is simply that if JEA 2301 in this court's view is nothing but an ASP amendment,
Right.
it's that and nothing more, then on that hypothetical, then TSOB ratification wouldn't be required. But again, our position being that it did more than that. They're trying to use an ASP amendment to amend a regulation, which is going to require a different procedure. And again, a guaranteed procedure, because the procedural guarantees are more than courtesies that we hope will be afforded. I mean, they're guaranteed by statute. And because we weren't given that, they didn't follow the correct procedure, airports respectfully requesting that this court reverse the denial of the petition for reconsideration and vacate JEA 2301.
And so just to follow up on the waiver issue that we've talked about, there's a line of argument that you didn't raise these arguments before the agency, therefore they're not exhausted. The government didn't raise the fact that you didn't raise them, so they've kind of waived their waiver argument. But we have case law that says the government can't waive these types of arguments because it's jurisdictional. But you haven't argued that it's not jurisdictional. So you've waived the argument that it's not jurisdictional, having.
And I'm sorry, Judge, was that a question?
I'm just, do you agree with me that you've not raised that and therefore you've waived any argument that these waiver arguments are jurisdictional?
I disagree with the proposition that we didn't raise those for the reasons that I've already stated, but I also would put forth that the statute requires that an objection be made. It doesn't require that the petitioner be the one that made the objection, just that an objection was made. And again, in the memo to the TSA administrator that I referenced before, it listed, not even all, but it listed objections that were made. The statute doesn't require that it be Spokane Airport Board make it. It just requires that an objection be made. An objection was made. It was acknowledged by TSA, and I believe it's preserved.
Thank you.
Thank you, counsel. Thank you to
Thank you,
both
judges.
counsel. We'll take this case under submission.